thank you so much for joining us. I hope this finds you and all of your loved ones healthy and doing well. And if you're in the Bay Area, I hope you're enjoying our spring weather at the end of February. I want to do a couple of things this afternoon. I want to give you an update on the law school, and then I'm delighted that I was invited to talk about my new and forthcoming book, and then save plenty of time for questions in the last third of the hour. So let me get right into it and give you an update on the law school. There's a lot of good news, there's some concerning news, but lots to tell you about. Let me start first with instruction. As you know, last March 16th, we transitioned to all online instruction. All of our classes have been online in the fall 2020 semester and now in the spring 2021 semester. It went remarkably smoothly when we transitioned last March. There's also no doubt from what faculty and students are saying that the quality of the instruction has continued to improve as faculty and students have gotten more used to the medium. It's an enormous credit to our faculty and to our students that they've made this transition. It's also a real credit to all of our staff, and particularly our IT and educational technology staff that have made all of this work. I always read all of the student evaluations each semester, and it's interesting to see them this past fall. Usually the median score for all of our classes in the law school, other than small seminars, is about 6.01 on a 7-point scale. This past fall, it was 6.10, so slightly higher than usual. And in reading the student comments, it was clear that they appreciated the efforts the faculty had made to teach over this new Zoom medium. And yet there's no doubt that this has been a very frustrating experience for our students. Many have suffered great hardships over the course of the last year. Many of their family members have suffered hardships. I think it's especially difficult for our 1Ls and our LLMs. They've never had the chance to meet their cohort. They've never been in the building because it's all online. Many of our students are feeling very isolated. We've tried to increase our mental health services for our students. And I think everyone, faculty and students alike, are just tired of being on Zoom. We're looking for ways to provide more community events for students, for staff and faculty. And yet what I also hear from students all the time is we want to have more community events, but we don't want them to be over Zoom, which is of course very troubling. We want to try to open some facilities in the law school for students to use as study space. This hasn't been possible because by city and campus rules, we've had to be closed. But as slowly things open up, I'm hoping we can begin to make some space available to students who need it for study. Fall plans are uncertain. I want us to be in person as much as the public health situation and as much as city and campus rules allow. My ideal will be we'll back to normal and we'll be entirely in person. It's certainly possible that we'll need, for public health reasons, campus rules, to have hybrid blended classes with some in the room and some online, though the hope is as soon as possible, we'll return to normal and we'll be all together in the building again. I've been teaching on Zoom all year. I taught federal courts in a seminar in the fall. I'm teaching con law in a seminar on civil liberties and pandemic this semester. We can do it. We can still provide excellent education, but it's not the same as being in a classroom together. Second thing I thought I would talk about concern admissions. And let me talk about JD admissions and then LLM admissions. In terms of JD admissions, it's just great news. We have had a dramatic increase in our applications. Last year, we had just over 5,000 applications. This year received just over 8,000 applications. That's a stunning increase in 1 year. Nationally, law school applications are up about 25%, but we're up way more than that. And it also appears that we're up across the board. I think we're going to be able to increase our median LSAT and GPA scores, and that's important, including for our rankings. But I also think we're going to be able to continue to increase our diversity. One of the things that I'm most proud of is the way in which we've been able to increase diversity in recent years. My first year here as dean in the fall of 2017, we had 12 African American students in the first year class. We increased that to 28 African American students in my second year, to 33 African American students last year, and to 43 African American students in the first year class this year. We were able to do that largely through the efforts of our alumni and our faculty and students who have aggressively reached out to admitted students. We have more Native American students than we've ever had before in the law school. We continue to be, of the top 20 schools, the school with the largest percentage of women students. Again, this year at about 65% women students. And all of this bodes very well for next year as we look at those who we've accepted. And for all of you who are involved in helping us to recruit those accepted students, my enormous thanks. For the LLM students, this was a tough year, and I'll talk more about it. We had a dramatic decrease in our LLM class this year. It's understandable. The LLM students want to spend a year in Berkeley, and because of travel restrictions, that was impossible. If you add up all of our LLM programs, we had basically a 50% decrease in the number, more than a 50% decrease in the number of LLM students attending. The good news is applications are strong for next year. We have many students who deferred. If we can be in person, I expect our LLM class to rebound to what it was. Our target for next year is about 320 JD students, which is what we'd hoped for this year in the entering class, and about 220 LLM students, which is a little smaller than we've been, but we want to try to make sure that we have a very manageable size of our overall student body. So the news there is good. Third, our news with regard to faculty hiring is really good. Since the fall of 2017, we have added, or we've hired 19 faculty members. I doubt there's any law school in the country that's hired 19 faculty members during this relatively short time. And the faculty we've hired are truly terrific. We've hired great faculty at the lateral level, great faculty at the entry level. Recent lateral faculty hires include Kiara Bridges, who was a tenured professor at Boston University, Jonah Gelbach, who was a tenured professor at the University of Pennsylvania Law School, David Graywell, who was a tenured professor at Yale Law School, Warren Kerr, who was a tenured professor at the University of Southern California Law School, and then just terrific entry-level faculty. This year, hiring Asad Rahim, who has just impeccable credentials, Harvard Law degree, PhD from the Jurisprudence and Social Policy program. And a year ago, we hired 5 wonderful entry-level faculty. And even with all of this hiring, we have about 10 slots remaining to be filled in the next couple of years. We have 3 outstanding offers right now. I expect that we're going to be making another offer later this afternoon and another offer later this semester. So even in the face of restricted hiring because of all of the budget difficulties, we're continuing to grow the faculty and just hire outstanding individuals. Fourth, let me talk about development. We're essentially on pace like last year overall with regard to the development efforts. And it's such a tribute to Mary Matheran and all of the development staff of what we've been able to do. There have been some stunning gifts that by themselves, of course, would put us ahead of last year, but let me set those aside for the overall numbers. You might have read of, I hope you've heard about, we received a $10 million naming gift from the Helen Diller Foundation for our Institute for Jewish Law and Israel Studies. I don't know this for sure, but a $10 million gift is certainly one of the largest that Berkeley Law has ever received. We've also received several wonderful 7-figure gifts for student scholarships. As I'll talk about, we need financial assistance from our alumni now more than ever. And so the gifts that we've received make a huge deal and are just an enormous difference for us. We're creating an initiative, which we're going to call the Leadership Council. And what it's going to be is asking some of our most loyal donors to make a 3-year commitment to provide us funds that would go to our general fund that we can use for scholarships, use for faculty support. We still lag way behind our peers in annual giving. We're at about 19% of our alums who do annual giving. University of Virginia Law School is a peer school to us. It's right next to us in the US News ranking always. They have 56% annual giving. The other top public school that's in the top 10 always is Michigan, and they have over 35% in annual giving. We're at 19%. So I hope creating a leadership council where we ask our alumni who wish to be part of this, and I invite any of you to do it, to make a 3-year commitment to us, and would be so enormously appreciated. But overall, there's exciting news with regard to development. Fifth, we continue to provide great community service through our pro bono program and our clinics. I've been particularly impressed with services that have been provided in light of the COVID pandemic, service to small businesses that are suffering as a result of closure orders, help to those who are dealing with immigration difficulties. Deborah Schlossberg, our director of pro bono programs, has done a great job of engaging students, albeit through this new medium. I think, again, we will have well over 90% of our first-year students doing slips, doing pro bono projects, and our clinics, in-house clinics, East Bay Community Law Center, providing great service to the community. So those are some of the great things that I can talk about that are happening at Berkeley, notwithstanding COVID and shelter in place. The hard part is this has been a very difficult budget year for the campus and for the law school. The campus estimates that it is going to lose about $300 million in revenue this year as a result of COVID. This is things like lost residence hall and dining hall revenue. This is things like lost athletic revenue. Some of it has been offset by federal stimulus money. Some of it's been offset by taking from the campus reserves, but they still estimate about $180 million deficit when all is said and done at the end of this year. Well, let me talk about what it's meant for the law school. The campus cut funding to each school on campus to make up some of that deficit, and they cut the law school $2.5 million. Also, as I mentioned, we lost significant LLM revenue. As a result of the decrease in the size in the LLM class, we lost $9 million in LLM revenue. Also, we get an allotment each year from the Office of the President for our public interest programs. They reduced that from $1.8 to $1.3 million. If you add up what I just said, it's a loss of $12 million in revenue for the law school. Our overall budget is about $115 million. So to lose $12 million out of that is a pretty significant hit in 1 year. We've been able to somewhat close the gap by we're not paying for any travel this year. We're not having events in the law school where we pay for food. We've had a soft hiring freeze, leaving some staff positions open. But still, we are running a deficit this year. Now, we have reserves. We were going to use those reserves for a construction project. If you remember, on the top of the main law building, there's unused library stacks. They were the stacks until the new addition was built in 2012. Since 2012, they've just been empty. And we were going to spend about $20 million to convert that to usable space, 15,000 square feet of usable space. It would help us solve a desperate space problem. In early March of last year, when COVID was emerging, even before we went to shelter in place, I got in touch with the vice chancellor and said, let's put that on hold. I'm too afraid of spending the money. The construction was supposed to start on May 18th, right after commencement, and be done for fall 2021 classes. But I'm very glad that I put it on hold because it provides us the reserves. So we've been able to get through without needing to lay off any staff. We have terrific staff, and I'm absolutely committed. We're going to protect all their jobs. And we've not cut our educational program in any way. We're not offering one class less than we would were we in the building. But we are running a deficit. And for all of our alumni, if you're considering helping us, this is a time we really need the assistance. If you're somebody who helps us financially, we thank you. And maybe if you could reach a little bit deeper this year, um, it is a tough year for us, having lost that $12 million in revenue compared to a year ago. So that's my report on the law school. It's, as I say, a lot of good news, some concerning news, but that's where we're at. And when I get to the question part of my remarks, I will be glad to answer anything you want to ask me about what's happening in the law school. The second part of my remarks, quite different. I was so excited when the development staff asked me if I would talk at this town hall about a new book that I have. The book will be published this summer. It's titled Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. In January 2019, a little over 2 years ago, I signed a contract with Norton to write a book for a general audience about the Supreme Court and police. And it reflects my sense that the Supreme Court, over the course of American history, has not adequately enforced the provisions of the Constitution that are meant to limit the police, but instead has really empowered the police. And this is manifest particularly with regard to very racialized policing in the United States. In late May of 2020, there was the tragic death of George Floyd. There were protests about policing in literally every one of the 50 states. I then got a call from my editor at Norton, Bob Wiles, saying, "Where's your book?" It was due September 1st of 2020. He said, "I want to get it from you as soon as possible and publish it since it's about the police." I confess that with COVID in the spring of 2020 taking so much of my attention, I was behind in writing the book, but promised that I would get him the manuscript by the end of September. And I turned it in, and it's going to be published this summer. Let me talk a little bit about the thesis of the book and take an example from the book. And then, of course, again, glad to take questions. I begin the book with the story of a specific Supreme Court case, City of Los Angeles versus Lyons from 1982. Adolph Lyons was a 24-year-old African-American man in Los Angeles. He was stopped late one night by a police officer wearing a burnout taillight. The officer ordered Lyons out of the car. The officer slammed Lyons' hands above his head onto the roof of the car. Lyons complained that the keys he was holding were cutting into the skin of his palm. The officer then administered a chokehold on Lyons and rendered him unconscious. Lyons awoke. He was spitting blood and dirt. He had urinated and defecated. The officer gave Lyons a traffic ticket for having a burnt out taillight and let Lyons go. Lyons did some research and discovered to that point 16 people in Los Angeles had died from police use of the chokehold, almost all like him, African-American men. Lyons sued the city of Los Angeles for an injunction to stop police from using the chokehold, except when necessary to protect the officer's life and safety. The Supreme Court, 5-4, ruled that Lyons lacked standing to seek an injunction. The court said Lyons could not show that he personally was likely to be choked again in the future. The court said a plaintiff like Lyons, who's seeking an injunction, has to show a likelihood of future personal injury. Thus, courts around the country have been rendered unable to deal with the problem of police use of the chokehold. And so, African-American men like Eric Garner or George Floyd continue to be killed by use of the chokehold. To me, this case is representative of a Supreme Court that has not adequately checked the police or enforced the Constitution's limits. After the initial chapters, the book looks historically at the Supreme Court. Part two of the book looks at the Supreme Court prior to 1953 with regard to policing. Then there's a chapter on the Warren Court from 1953 to 1969, a chapter on the Burger Court from 1969 to 1986. Then I look at the Rehnquist courts and the Roberts courts together that span from 1986 through the present. And then the last chapter offers my recommendations for reform. In the book, I look at specific aspects of policing. I focus on police searches and arrests. I look at police interrogation. I look at police identification procedures. And I focus a great deal on the remedies, or really I say the lack of remedies. Let me use a few minutes now to talk about one of the areas that the book focuses on, and that's police stops and searches. What I say in the book, what I think I can show you in just a few minutes this afternoon, is that the Supreme Court has empowered the police so they can basically stop any person at any time. Study after study shows that this power is used in a very racialized fashion. Every study in this cities large and small across the country shows that police disproportionately stop Black and Latino men much more than they stop others. Well, why? How did it come to be that the Supreme Court has so empowered the police? The Fourth Amendment was adopted in 1791. It says that the police are allowed to stop someone, to seize someone, and search them only if there's probable cause. And there generally needs to be a warrant. It might surprise you to know that for the first century of American history, there were no Supreme Court cases dealing with the Fourth Amendment. Go to the late 19th century before you find the first Supreme Court case interpreting and applying the Fourth Amendment. What it means is that police during all of this time were able to stop, arrest, search without constitutional constraints. The Supreme Court in the first part of the 20th century, prior to 1953, generally ruled in favor of the police when it comes to those police actions and didn't create limits. There's no doubt that the Warren Court in many ways imposed limits on the police. And yet the Warren Court, that we regard as the most liberal in American history, also empowered the police in a very significant way. The case was Terry versus Ohio in 1968. It involves a police officer in Cleveland, Ohio. He saw two men on a street corner. The men were Black. He said the men were walking back and forth in front of a store. He initially said he saw them walk back and forth in front of the store 4 times. As the case went from the trial court to the appellate court to the Supreme Court, the number of times they paced back and forth increased and ultimately became 23 times. But initially, the police officer said he saw them walk 4 times, back and forth across the street. At one point, they were joined by a third man. The officer had no other reason to suspect them other than they were pacing in front of a store and up and down a sidewalk. The officer then decided to seize the men, to stop them. The officer with his gun ordered them into a store, and then the officer frisked the men. And on one of the men, Terry, the officer found a gun and arrested Terry for unlawful possession of the gun. Well, Terry moved to exclude that gun from coming in as evidence against him. Terry said, the Fourth Amendment requires probable cause that somebody's committed a crime. There was no probable cause here that I committed a crime. I did nothing but something that's legal. Walk back and forth across the sidewalk. But the Supreme Court, in an 8-1 decision, ruled against Terry. Chief Justice Earl Warren wrote for the court. Only Justice William Douglas dissented. Chief Justice Warren said that the police can stop somebody so long as there's reasonable suspicion. It doesn't have to be probable cause. The police can then frisk that individual so long as there's reasonable suspicion. There doesn't have to be probable cause. There's many things that are of great concern with regard to this opinion. The Constitution doesn't speak of reasonable suspicion. It says probable cause. Reasonable suspicion has never to this day been defined by the Supreme Court. In fact, in 2020, the Supreme Court said in Glover versus Kansas, reasonable suspicion is more than a hunch, but less than probable cause. Also, it was predictable that this would further empower the ability of the police and the likelihood of the police engaging in racial profiling. The NAACP Legal Defense Fund filed a brief in the Supreme Court in Terry versus Ohio, lamenting racial profiling and talking about how a relaxed standard, reasonable suspicion, would increase racial profiling. Yet, what was the most liberal Supreme Court in history in 1968, with a majority that included justices like Earl Warren, William Brennan, and Thurgood Marshall, approved this. I spent a lot of time thinking about why did they do that. I think you've got to put it in the context of 1968. It was a very tense time. There had been many riots in major American cities. Watts riot in 1965 in Los Angeles, riots in Detroit, Newark, and other cities. The Warren Court had come under great fire for its decisions advancing the rights of criminal defendants. Decisions like Mapp versus Ohio, Miranda versus Arizona. There was a great concern about crime being out of control at the time. 1968, Richard Nixon was running for president against the Warren Court and saying he would appoint strict constructionists who would favor law and order. And I think all of this pressure had a real effect on the Warren Court. And so it said police can stop anyone so long as there's reasonable suspicion, a standard never defined. And it also said police can frisk somebody so long as there's reasonable suspicion the person has a weapon. All the police officer needs to say is, I saw a suspicious bulge that to my trained eye looked to be a weapon, and then be able to engage in a frisk. The Supreme Court then built upon Terry versus Ohio in a way that further empowered the police. I think one of the most important decisions in this regard, what's not widely known, is Wren versus United States from 1996. Some undercover police officers were driving in Washington, D.C. They said it was, quote, a high crime area, which in this instance was a euphemism for a neighborhood that was predominantly individuals of color. The officers said that they saw a car stopped at a stop sign for an unusually long period of time. They said it was stopped there 30 to 40 seconds. I have the world's worst sense of direction. I am often stopped at stop signs for 30 to 40 seconds. It used to be to try to read a map, which I'm incapable of doing, it seems, or now to look at my GPS. But based solely on this, the officers decided to follow that car. They followed the car until the drivers made a turn without a turn signal. They then pulled over the car and ordered the driver and the passengers out of the car. They did a search of the front of the car and found drugs. In DC, undercover police officers are not allowed to enforce traffic laws. Nonetheless, clearly as a pretext, the officers pulled over the car for turning without a turn signal. The United States Supreme Court, an opinion by Justice Scalia, ruled in favor of the police. Justice Scalia said, writing for the court, so long as the police have reasonable suspicion, let alone probable cause, that a traffic law has been violated, police can pull over the car. The court said it doesn't matter that the subjective motivation was pretextual. Of course, it doesn't matter if the police were motivated by race. So long as they can articulate reasonable suspicion or probable cause, they can pull over the car. Think about it. This really does mean the police can pull over any car at any time. If the police follow any driver long enough, at some point that driver is going to go 1 mile over the speed limit, or change lanes, or turn without a turn signal. Or the police can say, the car came to a stop sign and made a rolling stop. That's so subjective. And then the police are allowed to order the driver and passengers out and do a search of the car. But it's not just about cars and the ability of the police to stop almost anyone at any time. Let me tell you of another case, Illinois versus Wardlaw. Man was walking down the street and he saw 4 cars coming towards him that seemed to be unmarked police cars. He said he knew from the caravan way they were following one another that they were undercover police officers. And so he decided to walk in the other direction from the cars that were coming at him. He just changed direction and went the other way. To that point, he hadn't been suspected of anything. He was just walking down the street. But one of the cars, of those 4 police cars, became suspicious of him because he turned around and walked the other way. And the police car pulled him over solely on the basis of this and nothing else. The officer stopped him. The officer said he saw a bulge that was suspicious and a bag being carried by Wardlaw. Opened up, Wardlaw had a gun, and he wasn't allowed to possess it, and he was arrested for that. The question is, was there reasonable suspicion within the meaning of the Fourth Amendment? And the Supreme Court said yes. The Supreme Court said his behavior, just turning and walking in the other direction, was sufficient for reasonable suspicion. Given the record of police violence, especially against men of color in many cities, it seems quite rational that a young African-American man, in seeing police, might want to turn and go in the other direction. I did a study about the Los Angeles Police Department about 20 years ago and documented the extensive racial profiling and violence against people of color. I think it was quite rational for somebody to do what Wardlaw did. But the Supreme Court said that was enough for reasonable suspicion and probable cause. Now, I've picked just 3 cases that establish this. I could show you so many more. I can also talk about how the Supreme Court has limited remedies against the police when they do violate the Fourth Amendment. The Supreme Court has greatly lessened when the exclusionary rule will lead to evidence having to be suppressed as a result of police violations. The court has said you can't sue police departments generally for injunctive relief because no plaintiff can show it'll happen again. The Supreme Court has made it very difficult to sue cities or officers for monetary relief. So this is one of the examples that I focus on in the book. The last chapter offers my recommendations. I offer many things that I think can be done. One is legislation. After the death of George Floyd, bills were introduced into Congress and in many state legislatures, including California, to reform policing. Bills in Congress, for example, would change police practices, outlawing the use of the chokehold, outlawing no-knock warrants, which led to the death of Breonna Taylor in Louisville, Kentucky. Also, federal law would make it easier to hold cities and police officers liable. There are proposals in California to increase police accountability, and I describe what I think needs to be done in this regard. I urge more use of state courts and state constitutions. States always can provide more protection of rights than the US Constitution. Several states have rejected Wren and have said that pretext can't be a basis for a stop. Some states have rejected Terry versus Ohio and require probable cause. And I think, especially in light of the ideological composition of the Supreme Court, there needs to be more reliance on state courts and state constitutions. I recognize that it's much better to have the Supreme Court protect rights for the whole country. I recognize that it's not going to be successful in all 50 states, but I do think it's important. There's also a federal statute, 42 United States Code, section 14141, that allows the Justice Department to bring actions against police departments when there's a pattern and practice of civil rights violations. These have been tremendously successful in many cities. I had some involvement with a Justice Department suit against the city of Los Angeles that led to a consent decree that brought about reforms. A study was done by the Kennedy School at Harvard as to how successful these reforms were in limiting racialized policing and also police-caused deaths. Similar consent decrees were issued in many other cities: Baltimore, Cincinnati, Seattle. The Trump administration said that they were not going to use Section 14141, and they weren't going to enforce existing consent decrees. My hope is that the Biden administration will change course. Ultimately, I'm hopeful that the energy that led to protests in all 50 states after the death of George Floyd will lead to these reforms. I think that there is a meaningful opportunity for change, and I'm so hopeful it will occur. Well, I was instructed to talk to 440 and use the remaining 20 minutes for questions. I'm glad at this stage to take questions about anything with regard to the law school, or of course, anything with regard to my book that'll be out this summer. And if you send them in, I think, Whitney, they may be a Q&A or chat, is that right?
Yeah, we're using the Q&A function today.
Just Q&A, okay.
Yeah, so please go ahead and send your questions there, and I'll be reading them to Erwin.
And if you haven't met her, this is Whitney Mello, who is my terrific executive assistant. And
very nice to be here. And we do
I'll
have
the questions.
Great, we have a couple to start. So from Peter Fox, news today included that regarding argument before the U.S. Supreme Court in the case of Lang v. California, wherein a driver who appeared to violate noise ordinance was pursued by police to his home and then into his closed garage. The hot pursuit doctrine, permitting police to enter a home without a warrant when they have probable cause to believe a felony has been committed, threatens to expand to include situations in which they may have probable cause of the commission of a misdemeanor. The Chief Justice commented that the distinction between felonies and misdemeanors is, quote, very hard to draw, unquote. What is your prediction for and your reaction to the above case?
Sure. The Supreme Court, in cases like Warden versus Hayden and Payton versus New York, carved an exception to the warrant requirement for, as the questioner points out, hot pursuit. If the police are chasing somebody and the individual then enters a residence, the police can enter without needing to get a warrant. Hot pursuit. The case Lang versus California, though, asks the question of, does the hot pursuit doctrine also apply if the crime is a misdemeanor? Lang is driving in his car and has his radio loud and was honking his horn. This would be misdemeanor offense. The officer follows Lang, doesn't put on the lights and siren to pull over, follows him. Lang pulls into his garage and is closing the garage. The officer sticks his foot in to keep the garage door from closing. The officer enters the garage and says he then smells alcohol on Lang and arrests him for DUI. Remember, what the officer's basis for entry was is the misdemeanor: playing the radio too loud, honking the horn. The California courts extended the hot pursuit doctrine to misdemeanors. I disagree with Chief Justice Roberts that it's hard to draw the line between felony and misdemeanors. Every state has crimes designated as felonies, and every state has crimes designated as misdemeanors. Now, that may vary from state to state, but the states still do that, and some states have another set of offenses called infractions. You ask for my prediction. I worry that the Supreme Court is likely to affirm the California courts and extend the hot pursuit doctrine to misdemeanors. I think it fits with my general thesis that the Supreme Court has been empowering the police, and this further empowers the police to be able to enter residences without a warrant, taking the hot pursuit doctrine from felonies and including misdemeanors with it.
Thank you. From Roy Combs, thank you for information on the law school's commitment to diversity, including Native American students. Can you estimate enrollment trends beyond 2021-2022, particularly among African American, Latinx, and other students of color? Among these students, how does Berkeley law compare today, and what efforts are contemplated to try and improve Berkeley law's standing?
Sure. The best way to predict is to look at where we've been. And I say in the last 4 years, we've gone in the entering class for African American students 12 to 28 to 33 to 43. And it really is because of a very aggressive effort to encourage African American students to enroll. We've had a slow but steady increase with regard to Latinx students. We've had a dramatic increase with regard to Native students. We have an increase, though, a significant number of Asian American students as well. We're now over 50% self-identified students of color. Remember, we operate under Proposition 209, so we can give no preference in admission on the basis of race. Our admissions process does not take race into account because we're required by Prop 209 to not give any preference on the basis of race. When I arrived here in 2017, I was very concerned to have only 12 African American students in the first year class. And I asked our admissions staff and our equity inclusion committee to analyze why was this so. Was it that Black students weren't applying to Berkeley Law? Was it that we weren't accepting them? Or was it our yield was poor, they weren't coming? And we discovered it was the last of those. And in some ways, it's the one that would be easiest to tackle. It'd be harder to increase admissions in light of Prop 209, and it's hard to reach prospective students to encourage them to apply. But we saw the real problem was yield. And so together with Mary Matherin and our great development staff, we recruited alumni to help us recruit students. We relied on our faculty and our students to help recruit students. And we've been able to steadily increase diversity. I'm very encouraged based on the numbers that Kristen Theus-Alvarez, our director of admissions, showed me, that we are seeing a significant increase in applications of minority students, as well as the whole pool increasing. So I'm hopeful that this trend will continue.
Will you be virtually touring to discuss your book? Getting more people armed with the information you offer could spark a broader debate. It needs to go beyond members of the bar. The state bars have been less open to this type of reform. Community members can focus on state legislators if they have access to the information. Thank you for your work in this area.
Thank you. I'm excited about the book. I have a wonderful publisher in Norton. It's a trade press, so it's for a general audience. It's written for a general audience. Bob Weil, who edited the book, is the best editor I've ever had and was very attentive to the places where I was using phrases that I thought everybody knew, that he said, no, like I always think of the phrase bright line rule as something that people would know. And he goes, no, that, you need to write this in a way to be accessible and engage a general audience. And I'm hopeful that the book will do so. I would be thrilled if there's the opportunity to do a virtual book tour. Given my day job, I'm limited in how much I could go and do an actual book tour. I can't go away from the school for a period of time to go. I'll be teaching in the fall, and being a dean is really a more than full-time job. But virtual appearances are much easier because I can do them from my laptop. So I hope very much that Norton will help me set up the opportunity to talk about the book whenever possible and do media appearances about it, because I want to get the word out about it.
Is there a standard you would support between reasonable suspicion and probable cause?
I think we should adhere to the Constitution here, and the standard is probable cause. It's interesting, I'm not a textualist and originalist by nature, but if one were a textualist and originalist, the Constitution and the Fourth Amendment is clear. The only standard that it allows is probable cause. I think it's a standard that's come to have meaning over a long period of time. I think the court made a huge mistake in having a watered down standard, reasonable suspicion. So no, I would not have a standard between reasonable suspicion and probable cause. I would say probable cause should be the standard for any police seizure, any police search.
Would legislation help strengthen the Fourth Amendment, codifying the best possible interpretation?
Yes, legislation can very much provide protection of rights where the courts haven't done so. Um, so, I'll give an example. Well, the examples I mentioned in my talk, um, the Supreme Court has made it impossible to use litigation to stop police use of the chokehold. Many state and local governments have adopted laws that prohibit use of the chokehold, but most have not. And Congress should pass a law that says that the police can't use the chokehold, at least except if the officer's life or safety depends on it. Um, the other example I mentioned is the Supreme Court has said that there can be no knock warrants. The problem with a no knock warrant is when the police enter, those in the house don't know who's coming in, and it often leads to a gunfight. That's what killed Breonna Taylor, a no knock warrant. There's a bill in Congress to outlaw no knock warrants. Some state and local governments have done that. But that's true with regard to all police procedures. Um, uh, I'll give another example. The Supreme Court has said that police violate the Constitution with excessive force if the police action is unreasonable. International law says that police, if they're going to use deadly force, have to have it be necessary. The California legislature, a summer ago, passed a bill that says police use of deadly force needs to be necessary, not just reasonable. There is a place where the statute has gone further than the Fourth Amendment standard with regard to excessive force.
What is the difference between a detention and an arrest?
The key word in the Constitution is seizure. And a person is seized if a reasonable person would not feel free to leave under the circumstances. So, and that comes from United States versus Mendenhall. Whether a person is stopped by the police, or the word of the questioner, detained by the police, or arrested by the police, it's all a seizure for the purposes of the Fourth Amendment because a reasonable person under the circumstances would not feel free to leave. Now, if it is a stop, then it's reasonable suspicion. If it's an arrest, then it has to be probable cause. And the Supreme Court has never drawn a clear line to distinguish when is it a stop and when is it an arrest. And when I teach criminal procedure, we look at the kind of factors that are examined. How long is it? A stop tends to be shorter, arrest tends to be longer. What's the language of the police? Do they say you're under arrest? Is the person put in handcuffs and the like? But whether it's a stop or an arrest, if a reasonable person would not feel free to leave under the circumstances, it's a seizure for purpose of the Fourth Amendment, and the Fourth Amendment applies.
I wanted to ask what your thoughts on Supreme Court expansion beyond 9 justices are. While you outline the importance of state courts and governments protecting civil rights, it does not change the fact that we are facing a lengthy period, in addition to an already lengthy period, of control of the court by justices willing to empower police.
I favor, and have argued for this in op-eds, increasing the size of the Supreme Court, but it's not likely to happen. To explain, the Constitution says nothing about the size of the Supreme Court. It's set entirely by statute. The Supreme Court has had between 5 and 10 justices over the course of American history. It was 5 in 1787, then became 6, then went back to 5. And as the country grew, they kept adding another Supreme Court justice until it got up to 10. Hard for us to believe they really wanted an even number of justices. And then in the late 1860s, there was a terribly unpopular president, Andrew Johnson. He had been impeached by the House of Representatives, and Congress didn't want him picking a Supreme Court justice. So Congress said the next time there's a vacancy on the Supreme Court, we'll just eliminate that seat. And that happened in 1869. And it's been 9, a historical accident ever since. I think that the composition of the Supreme Court is a result of historical accidents and also what I would call Republican court packing. In terms of historical accidents, since 1960, we've had 32 years with Republican presidents and 28 years with Democratic presidents, almost even. In fact, in 2024, we'll have had 32 years with Republican presidents and 32 years with Democratic presidents. But since 1960, Republicans have picked 15 Supreme Court justices, and Democratic presidents have picked 8 Supreme Court justices. Some of that's just the accident of history. Richard Nixon had 4 seats to fill on the Supreme Court in his first 2 years as president. Donald Trump had 3 seats to fill in his 4 years as president. But Jimmy Carter had no vacancies in his 4 years as president. But some of it is also how the Republicans blocked Merrick Garland's nomination and then rushed through Amy Coney Barrett's nomination. As the question points out, what we have on the Supreme Court now is going to be with us for a long time. Think of the age of the justices. Amy Coney Barrett is 48 years old. If she stays on the court until she's 87, which is the age Justice Ginsburg died, Justice Barrett will be on the court until the year 2059. Neil Gorsuch is 53, Brett Kavanaugh is 55, John Roberts turned 66 last month, Sam Alito is 70, Clarence Thomas is 72. I think the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. So it's easy to imagine 5 or 6 of these justices being together for another decade or two. So I would like to see Congress expand the size of the Supreme Court to restore ideological balance, but I don't think it's going to happen. Any bill to increase the size of the Supreme Court is sure to be subjected to a filibuster by Republican senators. The filibuster was eliminated for judicial nominations and cabinet nominations, but not for legislation. And some Democratic senators, like Joe Manchin from West Virginia, have already indicated they're not going to vote to eliminate the filibuster. And so I don't see a way of expanding the size of the Supreme Court. There's a desperate need to expand the size of the lower federal courts. It hasn't happened since 1990. But again, I think the Republicans would filibuster that.
Will the projected increase in LLM attendance and returning to more normal classroom teaching permit the law school budget to be balanced over the next 2 years and build some reserves?
If we can restore the LLM program to what it was, and if the campus doesn't cut us further, yes, we will return to a balanced budget next year. And I hope very much we can go back to building reserves. We need the construction projects. I want to do the library stacks construction project because we desperately need 50,000 square feet. I want to renovate Booth Auditorium. We have a donor who's offered us $1 million to renovate Booth and create a courtroom there. And architects do a study and it'll cost us $5.5 million. I don't have $4.5 million to renovate Booth, but I wish we could raise the money to do that or build our reserves to do that. So if the LLM program rebounds, if we don't have further campus cuts, we will return to a balanced budget. This year we're in deficit. My goal by the time I'm done being dean is to have the law school be financially independent of the campus. I'm hopeful we can also then in exchange get more bureaucratic independence from the campus. But as I think about what I want to accomplish by the time I'm done being dean, I want us to not only have a balanced budget, but be financially completely removed from campus support. Now we get about 5% of our money from the campus.
So we've got time for one last question. As a practical matter, isn't the Supreme Court ruling in Terry versus Ohio and like cases also an attempt to recognize that with all the guns in the US, a decision was made to protect the police from harm? Isn't that a reasonable value to prioritize for the court?
Yes, protecting officers from harm is very important. But Terry versus Ohio is a tremendously over-inclusive way to do that. Because Terry ultimately lets the police stop virtually anyone at any time. There was a study done in New York by the Mullen Commission that came to this conclusion. And it said what police will do is stop people and then afterwards make up a justification for the stop. The Mullen Commission, chaired by a former judge, even coined a phrase about this, test-a-lying. It's one thing to say, that once the police stop somebody, they should be able to frisk the person for a weapon to protect the officer. I understand that. But I don't think we should say, because guns are so prevalent, let's let the police stop anyone anytime and frisk them. And anything they find in the frisk, whether it's gun or drugs or anything else, becomes admissible. I am very concerned about all of the statistics that I alluded to, but that I present in the book that show how much racialized policing occurs, how much people are stopped just for driving while black or driving while brown. Every time I teach criminal procedure, the black and brown men in the classroom tell stories about being stopped by the police for no other reason. Yesterday, University of California President Michael Drake spoke to the Council of Deans on campus, all the deans on campus, and he talked about the instances where he's been stopped by the police, where his sons have been stopped by the police for nothing but the color of their skin. And I think Terry versus Ohio opened the door to that. So yes, we have to protect the police officers, but I think Terry did so in a very over-inclusive way. I think this means that we're out of time, which I just so want to thank all of you for coming to this and being part of the law school and all you do to help the law school. And of course, want to thank everyone on our development staff in Whitney for making this possible.
Thank you so much, Erwin. And have a great evening, everyone.
Thank you. Thank you for coming.